Namaste students, I'm Professor Dr. Bina Diwan. So, yesterday I was discussed about section 23 and 24 of Arbitration and Conciliation Act 1996. Today we will be discuss about section 25 of the Arbitration and Conciliation Act 1996. Section 25 of the Arbitration and Conciliation Act 1996. Arbitration proceedings. Negligency of a party, opinion, unless otherwise agreed by the party, unless without sufficient reason. The claimant does not present a claim in accordance with the regulation. The arbitral tribunal terminate the proceedings under section 2 subclause 1b. The respondent does not file his answer according to section 23 subclause 1. The arbitral tribunal must proceed with the case without that failure in itself being a surrender of the claimant. If a party does not appear at an oral hearing or present documentary evidence, the arbitral tribunal will continue the proceedings and render an arbitral award based on the evidence presented to it. After arbitration, if a party did not appear on the adjourned date, despite the arbitrator noting in the minutes of the hearing that if the party doesn't appear on the day and time fixed, the hearing will continue ex parte and number is reported separately. The ex parte awardee is legal in that case. It was said in the case of Naga Shrivastava versus Glenda Price Limited 2009. Party who has been written to several times but don't appear before the arbitrator and unilaterally allows procedure to continue. Can't later claim that he was not given an opportunity to be heard If a party shows sufficient cause for failure to appear before the arbitrator, the court will vacate the ex parte award. As in High Court, White House versus Khan and Company, State of UP versus Combined Chemicals, 2011, the appellant sought a stay on the ground that he appealed the decision of the trial court to uphold the application. The arbitrator granted a stay, but the appellant not obtained a stay in the appellate court. And abstain from arbitration. It was said that the arbitrator had jurisdiction over such a party ex parte procedure. Just example, in this case, module was staged according to Farmer, 1871. It was held that an arbitrator who has signed which award in trust officio and can't change his award or change the slightest error in, even if the error arose from an error by the clerk in copying the award. Next point, termination of proceedings. Section 25, subclause A and section 32, subclause 2C of together would lead to the irresistible conclusion that the arbitrator can terminate the proceedings if the claimant failed to fulfill its claim. In Mohan Singh versus in India International Authority, 1997, the Supreme Court observed that although the word shall gives the prima facie the impression that it is mandatory, it must be considered in the light of the purpose by the legislator carefully, considering the scope, nature, and construction of the law, and the consequences arising from its construction in one way or another. It must be limited by a combination of important factors of public and public convenience. And therefore, provisions must be interpreted according to the prevention of public evil and the promotion of public justice. The basic principle of dispute resolution is that the arbitrator must know what the plaintiff's claim is and what the defendant objection is and what the significant factual and legal issues are. The arbitral tribunal may also return and order terminating the proceedings if it was made with the region and if the matter is found to be appropriate. Arbitration and conciliation laws. Section 26 and 27 contains number 1, arbitration and conciliation law. Section 26, appointment of expert by the arbitral tribunal. Appointment of expert, witness, and expert. Section 27 of the Arbitration and Conciliation Act, judicial assistance regarding testimony, characteristics of evidence, information required, authorization of the arbitrator to the court. Section 26 of the Arbitration and Conciliation Act, appointment of the expert of the arbitration. Opinion, unless the arbitral tribunal agrees otherwise with the opinion of the special expert on the special issues decided by the arbitration, require the party to provide the expert with all relevant information by providing access to related documents, good or other property for his inspection. If the parties do not agree, otherwise the expert must participate in an oral hearing after submitting his written or oral report, where the parties have the opportunity to question him if the interstate party requests it or if the arbitral tribunal deems it necessary questions and for expert to testify on disputed matters. Unless the party agree, otherwise the expert must at the party request make available to that party all the documents, goods or other property in the expert possession that have been handed over to him and prepare the report.